So good morning, everyone. Thank you very much for joining this WIPO Standing Committee on the Law of Patents briefing by the South Center. So we'll be discussing the upcoming 36th session. My name is Viviane Munoz, and I'm the coordinator of the Health, Innovation, Intellectual Property, and Biodiversity program of the South Center. And I'm joined here by two of my colleagues. Nirmalya, please go ahead.
Good morning, colleagues. I'm Nirmalya Shyam from the Health, IP, and Biodiversity program at the South Center. Pleasure to be with you here today. Thank you.
And we're also joined by our current intern, Eduardo. If you're able to join, oh, that's okay. So colleagues, we will proceed in the regular way we do our South Center briefing. So we'll have first a presentation of the South Center. This is a complement to the background note that has already been distributed, and this was distributed last week. If for some reason you are not aware of that background note, please let us know to our emails, myself or Nirmalya, and or Caroline and Gomez, who usually receive the communications from, and we'll make sure to send that to you. We also encourage you, if you can send that also to your capital-based colleagues who may be either coming to Geneva for the Standing Committee on Law of Patents or participating online. So we'll go briefly through which are the agenda items and the documents that are up for discussion of the SCP. And there afterwards, we will open up for any questions, comments, and general discussion among delegates. And as I mentioned, while we are currently recording this briefing, that will be done just for the general area. So with that, I'd just like to turn then to Nirmalya to head us off for the presentation. Thanks, Nirmalya.
Thank you, Viviana, and welcome to all colleagues joining us online today. Before we move on to the topics on the agenda for the upcoming session of the WIPO Standing Committee on the Law of Patents, perhaps it would be useful particularly for any delegate who is new to this, to refresh ourselves a bit about the mandate of the SCP and its past work. We have detailed this, of course, in the background note, and you could find that over there. So the Standing Committee of the Law of Patents was established in the late 90s, early 2000s, thereabouts, with the objective of looking at the progressive development, and this is the mandate of the SCP, to look at address the progressive development of the international law on patents. Its initial mandate or initial work pursuant to this mandate was to draft and negotiate a substantive patent law treaty, or the SPLT, which essentially attempted at that point of time to harmonize the global standards on substantive patentability criteria, namely the standard of novelty, inventive step, and industrial applicability, the period of grace period, etc. These were part of the negotiations in the SCP in its initial years for the first 3-4 years of its existence. One of the outcomes of the early outcome of the SCP of this was the PLT. Some of the issues which were in the larger patent harmonization scheme were taken out of the SPLT context, and that became the patent law treaty on the formalities aspects. But the substantive issues continued to be discussed in the SCP. The response of developing countries to these issues, and this was post-TRIPS, obviously, TRIPS had been adopted by then, was to raise in the SCP issues relating to how the patent system interacts with larger public policy goals. For example, the role of exceptions and limitations in the, and other flexibilities in the patent system as allowed under the TRIPS agreement, and how those that could be used to and how to sort of mitigate any adverse impact arising from the grant of patent protection in those respects, including health, environment, education, etc., access to technology. Now, one of the issues also that was being raised in these contexts was the issue of the patenting of products derived from genetic resources and associated traditional knowledge. This initiative of the developing countries, these demands of the developing countries were instrumental in two outcomes that spanned out of the SCP essentially. One was the adoption of the WIPO development agenda. There was a period since 2005 when the SCP was suspended. It did not effectively meet. No discussions could progress. This impasse was resolved with the adoption of the WIPO development agenda. And another outcome of this was also the establishment of the Intergovernmental Committee on Genetic Resources, Decay and Folklore, which over the past almost 2 decades of work now has resulted in the latest treaty on IP and genetic resources that was adopted earlier this year. So this is to set the work of the SCP in context, and to understand that sometimes it leads as in the past it has led to and can lead to in the future normative outcomes outside the SCP itself. So that's just a context to note. The current mandate of the SCP is to focus on discussions on issues based on a non-exhaustive list of topics. This has been ongoing since about 2008. Out of this non-exhaustive list of topics, which is there for reference of member states in the SCP documentation, the SCP in recent past has focused predominantly and almost exclusively on the following topics: patents in health, technology transfer, quality of patents, confidentiality of communications between clients and their patent advisors, as well as exceptions and limitations. Now, the agreement in the SCP or in the recent past for several sessions has been that the discussions are not intended to lead to formal norm setting. So this will be an exchange of ideas, exchange of views and perspectives, but there won't be any normative outcome happening out of this exercise, which will essentially mean that these discussions will maintain flexibility in national patent law design. However, it is important to also note that the current context where the SCP is not agreement in the SCP is not to touch on any normative issue is happening in the context of a number of demands from developing countries that are on the agenda of the SCP to address issues such as exceptions and limitations, use of TRIPS flexibilities for public health, etc. And it is in that context that you see a push coming in the SCP to sort of keep its work restricted to sharing of ideas and perspectives and not to touch on any rules, because the rules and therefore not disturb the status quo of patent protection and the standards that are there. So it's just a context to take note of. Of course, member states may propose considering additional issues for discussion at any point of time in the SCP, but so far in the recent past, this has not happened. For this upcoming 36th session of the SCP, it will be a continuation of the same items on the agenda as in the recent past, with variations in what specifically will be discussed under those items. So these are exceptions and limitations. There will be a discussion on the exception for extemporaneous preparation of medicines in pharmacies. I'll come to it in the next subsequent slides in a bit more detail, which 85 countries, according to a draft reference document that will be discussed in this session of the SCP, have implemented it, allowing pharmacists to create personalized treatments without infringing patents. Then there is the ongoing issue of quality of patents and opposition systems. So the focus of the discussions could include improving patent examination, opposition systems, and recent discussions have also focused on what has been the impact of artificial intelligence on patent processing. An agenda item that has been long pending in the SCP in the recent past has been patents and public health. Sorry, is there any question or something? Okay. Patents and public health, continuing, which will have continuation of analysis done in the past, say at the 25th session of the SCP, for instance, on patent flexibilities for developing countries, which would be updated in the light of enhanced challenges that developing countries faced in the context of COVID-19. One issue that has been of major interest for developed countries, which is on the agenda of the SCP, is confidentiality between clients and patent advisors. So essentially, it is the demand of some countries that any advice rendered by patent advisors to their clients in the drafting of a patent application should be treated as privileged communication, and that should not be subjected to any disclosure mechanism in further proceedings before the patent office, or for example in a court of law. The issue is all countries necessarily do not recognize this, as privileged communication is only granted by courts in the context of lawyers and not necessarily patent advisors, including to patent advisors working in the offices of lawyers. So, this is a matter that has been pursued for some time, but again, there is no agreement on norm setting at this stage, and there would be an exchange of views and ideas on this topic. Finally, there's the topic of transfer of technology and patents. In the recent past, the emphasis has been on patent law provisions that have contributed to effective transfer of technology, standard essential patents and FRAND licensing, and this session of the SCP will also discuss how patent inventorship and ownership issues arising from cross-border collaboration and in the context of university inventions can impact transfer of technology. Let's turn to exceptions and limitations to patent rights. The context of this work, and this is perhaps the most mature field of work in the SCP. As I have mentioned, in 2008, the SCP started to develop a work program for itself. Substantive patent law negotiations did not materialize. It wasn't successful. SCP started to work towards developing a new work program. In order to develop this new work program, a non-exhaustive list of issues was developed. One of the issues in that non-exhaustive list, which is continuing to be a focus of discussions in the SCP, is exceptions and limitations to patent rights. And out of all the issues so far discussed in the SCP since 2008, this is perhaps the most mature in terms of development of a work program. The context is there were proposals by Brazil that a draft reference document or draft reference documents on various exceptions and limitations should be prepared by the WIPO Secretariat, pointing out what are the utilities of different exceptions and limitations, in which context they are used, what are the legal practices countries follow, and so that these could then serve as a reference document to guide technical assistance work of WIPO. And when we talk about exceptions and limitations, from each session to the next session in the SCP, we are moving from one exception limitation to the other. But it is important to keep in mind that this is the ultimate objective of developing these draft reference documents on exceptions and limitations, that these documents, at the end of the day, should not end their lives in an SCP discussion, but should become a part of a toolkit for WIPO technical assistance delivery and be used for such. And that is something that member states need to follow up on, because we do not see
Good morning,
any.
Mr. Mike. Nice to talk to you. How are you? It's an absolutely pleasure for me to hear you.
Sorry, apologies for that. So we have. So that is where we need to go. The next step to be really taken, strategic step with regard to exceptions and limitations, is not to focus on specific reference documents, which of course we need to look at, but that is a part of a process. What we need to look at is achievement of the ultimate objective of exceptions and limitations reference documents, that these become part of WIPO technical assistance toolkit. And we have not seen anything from the WIPO Secretariat which points to how a number of these reference documents that have been developed in the past, presented in the SCP, positively commented upon, welcomed by member states, are used currently. Do they sit somewhere in the WIPO digital archives for the SCP, where you can go back and take a look at it, and nobody else gets to know about it? Then that's of not much utility. And that's something that we need to keep at the back of our minds. So for this session of the SCP, a draft reference document on extemporaneous preparation of medicines will be discussed. This exception is essentially an exception that is relevant to personalized medicines and pharmacogenomics fields as well. Traditionally, it meant that, in earlier times, you don't have it nowadays that much. When you would go to a pharmacist would essentially prepare a medication for you. In the context of whatever the doctor has prescribed. Sometimes they would do that. Such preparations of medicines, the question would be, would that be infringing any patent existing on a medicine? For example, you could be combining two medicines into a mixture and giving it to the patient. This exception basically would make such acts not an infringement of a patent that may be in force. While that has been relevant in these de minimis cases, going forward, these exceptions can also be of relevance to the use of to the emerging fields of personalized medicines and pharmacogenomics. Now, what we know from the reference document that has been presented is that 85 countries have implemented this, and there has been minimal adverse impact on patent holders from the implementation of this exceptional limitation, from the exception. Therefore, it is important to look at, to have a very forward-looking approach towards this exception to see, and these are essentially our comments, to maintain flexibility to ensure that, maintain this flexibility to ensure that patients can receive tailored treatments in the future. For example, we are looking at a future where we could be looking at 3D printed drugs, 3D printed pills, which could be a combination of different pharmaceutical preparations. And would this exception be of any relevance in that context? These are certain things to think through. Now, in addition to this, developing countries should also request further analysis in the SCP on other exceptions, namely security exception, which is the only remaining exception to be addressed. In the past, other exceptions have been addressed, including compulsory licensing, government use authorizations, the research exception, BOLAR exception. All of these have been addressed in past reference documents. The only one that now remains to be addressed is the one on security exceptions. And once this is taken up and done, then it would have exhausted the work on exceptions and limitations in terms of preparation of reference documents. Now, we are coming to a stage, as I said at the outset, under this particular agenda item, that we need to think through as to what next. We have there are so many exceptions available. We have prepared reference documents on these exceptions. Now, how do we make sure that these are being used as part of technical assistance toolkits and being widely disseminated and available to member states? That is the key on this item. If you have any questions on this, we can pause here. Otherwise, I could move on to the next slide. Yes, Maximiliano.
Well, thank you very much, Nirmal, and it's great to have the opportunity to make some comments. And
Thank you. Thanks a lot for those very interesting questions. In fact, a number of these would perhaps require much more deeper discussion and would probably require a separate briefing in itself. But also, Viviana, if you would want to jump in on any of these points, just to take off from the last point that you made on the exceptions on the IGC process and what was before. I mean, before the SCP was established, before it started discussing PLT, etc., one of the treaties that was being actually discussed in WIPO with generally was a treaty called the Patent Harmonization Treaty. It was a draft treaty, and what it was being discussed in the early 80s. And it's interesting to note that some of the provisions in that draft Patent Harmonization Treaty today can be found verbatim in the TRIPS agreement under the chapter relating to patents. So there was a shifting of the forum for strategic reasons, I think at the behest of developed countries. What is interesting to note is that when the Patent Harmonization Treaty discussions had emanated in WIPO, originated in WIPO, developing countries again brought forth development issues in the discussions. And it was not an easy ride to go forward with a patent harmonization agenda in the face of this, let's say, united developing country countries raising these issues. Of course, in the WTO, there were different dynamics, different issues, different agreements. You had a single undertaking approach, as various scholars of the WTO Uruguay round negotiations have pointed out, that led to this strategic shift of bringing IP itself into the WTO agenda. As you would be aware better than myself, economists who advocate for free trade, including Jagdish Bhagwati, for example, have also pointed this out, that you should not have had actually an agreement like TRIPS in the WTO, which is a very different kind of an agreement compared to other trade agreements. But long story short, I mean, this happened, and then when the SCP started discussing substantive harmonization issues, that was when developing countries again started bringing forth issues of misappropriation of genetic resources through the patent system. That was one of the primary issues being brought about, which developing countries wanted to be addressed as part of the discussions in the SCP. This led to that the spin-off into the IGC. And which brings me to the point that this understanding that prevails in the SCP currently, that there won't be any normative issues taken up. If you look at the list of issues on the agenda, you have exceptions and limitations, you have patents in public health, you have transfer of technology, and you have opposition systems and quality of patents. On all of these issues, quality of patents, there could be different perspectives, but on all of these issues, if one were to go for norm setting, the norm setting would be essentially towards enhancing, from a perspective of developing countries, towards enhancing the use of flexibilities, right? Not to rewrite the TRIPS agreement as such. You have the TRIPS agreement, it defines the flexibilities. It's also important to note that pursuant to an agreement between WIPO and WTO, a relationship agreement, technical assistance for implementation of the TRIPS agreement, including its flexibilities, are the responsibility that has been assumed by WIPO. So that is why it becomes very, very important to look at how to address these issues. And when we talk of normative issues, we're not just talking of treaty negotiations or hard law negotiations. Norms could be even in the form of model laws, guidelines, etc. The fact that SCP has this understanding right now that we are not going to touch any norms. Of course, on a strategic side, you could say that we are not going to go worse than we are, so there won't be any development of other norms. But one could counter that by saying, well, parties are pushing for TRIPS plus obligations, for example, in other forums, bilaterally, plurilaterally, etc., right? Regional trade agreements, etc. So the essence of this is that if for developing countries you want to develop norms such as guidelines on patent examination standards, etc., or model laws, these are also norms, and perhaps an understanding that we are not going to address any normative work could mean that none of these would develop. And essentially that would mean that what the SCP becomes is basically a talk shop where you exchange views, exchange ideas, and you just leave it at that. And that's what it has been for a while. Yeah. So I don't know if that answers all your questions, but yeah, I think that's the best I could comment on at this time. Yeah, Viviana, if you would like to share anything on this.
Sure. So just addressing the question about the history of the SCP with regards to norm setting. So of course, the SCP, as other standing committees, has a general mandate whereby it examines different issues, and if any issue is considered by the members that it is already ripe towards moving towards norm setting, then the committee will always be able by itself to determine that this is a particular issue that should be moved towards norm setting. So I think that with regards to the mandate, it's clear that any substantive committee, and this excludes the IGC, because the IGC has a separate mandate that is not like other standing committees. It's not a standing committee itself. But with regards to the SCP, the general mandate is the first broad mandate for the committee. Now, with regards to the understanding that was made about whether this body should move or not towards more norm setting, that goes back to 2007, as well as part of the development agenda discussions. And so what was an important element was that there was an impasse about what should be the future for the Standing Committee of Patent discussions. And what developing countries pushed for was for a balance between issues of interest of developing countries and of developed countries. So that's how a non-exhaustive list of issues came about in 2008, with the idea of saying, let's just everyone put what they would like topics for the SCP to decide. And it seemed that on none of those topics, it would still be time to move towards any norm setting, but that at least there would be an agreement to have a more balanced agenda of agenda items in the SCP. So that's how the list of non-exhaustive issues came about. And it was agreed that through the sessions, then different of those issues would be taken up. And as it's called, it's non-exhaustive, which means that member states could later add more issues to those list of issues. So the key issue was that this process helped to create a more balanced agenda where all the issues of developing countries and developed countries could be added to the agenda, so that there was no limitation to what issues could be added. So in that sense, the SCP has had this unique way of balancing or coming to an arrangement for a balanced agenda. So those agenda issues continue, and some of these are the important ones that are being taken up on this session. So with regard to that comment, with respect to the IGC history, I think there what we see is that we had a very different kind of committee establishment with a only a committee established only with one particular agenda, which though the agenda is very broad, it was to define only one particular issue, and the idea was that it was considered so important that it was given a timeline, a deadline. So the committee was only supposed to be for 2 years so that it would finish its work in 2 years. But what happened was that it became a recurring committee for 2 years. So just coming back to the SCP point, I think that just to highlight the linkage about balancing the agenda was a key one, and it's important for other committees that we can learn, including for CDIP, where it's been difficult even to balance the agenda discussions. And the second point, also being the reoccurring issue of norm setting, I don't think it's really problematic in the sense that, for example, if we mature the discussion, for example, on limitation exceptions on patents, if we are able to create specific work plan, because right now what we need is to advance on the work plan. What specifically does the SCP produce on limitations and exceptions for the SCP? There's been a lot of studies, a lot of discussions, but those have not, first of all, one thing we've been highlighting for a long time is that these studies should be published more formally by WIPO so that these become elements of guidance for our national office implementation. And we see that these studies, while very valuable, they're not even available really. So capital officials or national patent offices don't have direct access. They're not using all this information and studies that are coming out from the SCP. So one, we've been including saying, just make these studies published so that they can be made more available as reference documents, formal reference documents of WIPO. And other elements, as you see, that are being discussed now about each of the specific elements of the limitation exceptions on patents. Now, if there is an issue that is considered to be norm setting, then once it's defined, I think it could be advanced in that way. The issue is that we have to then balance against what might be the demands by developed countries. Because if we ask for a norm setting agenda, for example, on exceptions and limitations on patents for public health purposes, for example, even if it's specific on that issue, then we might have then, of course, developed countries also pushing for a more norm setting agenda, for example, whether it be on the issue of, as some had proposed for the client, these formalities, issue which normally will come to, or some other. And the more troubling one for developing countries, of course, would be any harmonization of substantive patent law, which would reduce any policy space that developing countries have for how they examine patents in a very rigorous manner. So that would be also to just examine trade-offs. If we do open up for norm setting, we should be very clear and ready for that. Otherwise, we should just continue to call it implementation of the work program on limitations and exceptions on patents, or on public health and patents, versus sounding an alarm on norm setting if we're not ready to go there.
Thanks, Viviana. So just thinking out aloud, one of the things that and thank you again for that question on the IGC, which sort of made me think about it. Now that we have a treaty on IP and genetic resources that has been adopted, of course, we have to look at its implementation. And there is an assembly for that treaty, which will meet annually. But then there is no other working group or committee, etc. And the question would be whether this should come back to the SCP because it is in relation to patents at this stage. This treaty is talking about disclosure in the patent system for genetic resources that have been utilized and associated traditional knowledge. Now, I think one of the issues that we could think through going forward is whether there could be an agenda item introduced in the SCP to look at the status of ratifications of this treaty and its implementation, etc. Just thinking out loud, this is my personal thought, and yeah, I think maybe worthwhile to consider. Did we have anyone raising hands? No, I don't see anybody.
Perhaps we can continue, Nirmalia.
Right, thank you. So let's move to the next issue, quality of patents in opposition systems. So under this item agenda, there are basically two distinct yet related items, quality of patents and opposition systems, as the heading suggests. The work in the SCP under this agenda item has been predominantly focused on the second aspect, on the first aspect, quality of patents, and not so much on opposition systems. In the initial days, there were some preliminary studies that were prepared on opposition systems by the Secretariat. And those studies essentially tried to portray opposition systems as an impediment to efficient processing of patents, etc. And there was this approach was criticized. These studies were criticized by developing countries, but then it was just a study, and the issue of addressing opposition systems sort of ended over there. So there has been no further follow-up activity for a number of years now in SCP, specifically on opposition systems. I think that's one point to take note of, that between quality of patents and opposition systems, the issue of opposition systems itself has been a bit of a neglected cousin, if I may put it that way. So focus on patent examination processes, opposition systems, and how AI challenges patentability are broadly within the rubric of this agenda item. There has been in recent past more discussion on how artificial intelligence generated inventions raise issues regarding patentability and disclosure issues, and there will be some further discussions in this session of the SCP on that aspect. But again, as we've pointed out in the background note, I think it's important for developing countries to push for a stringent criteria for examination and grant of patents and ensure full disclosure on patent obligations. I think the issue is that from the perspective of developed countries, as they have framed the issue on quality of patents in the SCP, the issue has been sort of addressed from the perspective of efficiency of the patent system or efficiency of patent offices in terms of grant of patent applications or disposal of patent applications. So faster rate of processing, faster rate of grant and disposal, and how do you achieve that? Given the problem that all patent offices have, and developing country patent offices have this problem more than others, of course, is that of the fact that there is a heavy backlog of patent applications. This is simply because patent claims are filed on multiple types of patent claims could be filed on sometimes a single product, right? So when you have a huge workload of patent applications and patent claims to examine and sift through, obviously it could lead to delays. If you're going to look at each and every one minutely, it could lead to delays. And that would sort of impact the efficiency of the patent office from a client perspective. And this is how the debate on quality of patents has largely been shaped, to explore solutions to this problem. And the solutions that are therefore presented to this problem are, why don't we share work products between patent offices? Why don't we do collaborative search and examination? Why don't we use automated artificial intelligence systems to do patent search and examinations? Now, one of the fundamental issues to take note of in the context of this discussion is, we are not essentially looking at the quality of the granted patent as the end product, but we're looking at the quality of the patent examination procedure as such in terms of disposal rates. Now, this is a bit of a very narrow perspective of what should be looked at as quality of patents. And developing countries have in the past brought this in the SCP, brought this out in the SCP. And pursuant to this, there have been studies in the past sessions of the SCP which have looked at sufficiency of disclosure, inventive step requirement, how these are implemented by different patent offices. But then the thrust continues to be on looking at collaborative search and examination and other kinds of work sharing arrangements. As some of you will know, that the European Patent Office, for example, has entered into bilateral agreements with a number of national patent offices to do the search and examination for search and examination products of European patent offices to be validated by national patent offices without any further search and examination. So, for example, if you have a medicine for which a patent is sought under the EPO, and the EPO grants that medicine a patent, and the same drug is under a patent application in your country, if you have a patent validation agreement with EPO, your patent office would essentially recognize the EPO patent as a national patent without subjecting it to further search and examination. Now, your national standards of what is patentable, what is inventive, etc., could be very, very stringent compared to that of the EPO. But then, if you just recognize an EPO granted patent as valid, unless somebody really challenges it in a court of law, then that would, as being contrary to what your legal standards are, what you could end up with is a patent that may be potentially invalid under your law, but has been effectively and very speedily granted, which is good for the effective disposal and efficiency of the office, right? So you have this binary problem which needs to be resolved. So we need to focus on both aspects of the problem of quality of patents. And therefore, what we recommend is that developing countries should push for discussions on stringent criteria for patent examination and grant of patents, and ensure full disclosure in patent applications, including in the context of AI-generated products for which patent claims are made, because the standards of what would be novel or what would be non-obvious or obvious would be different in the context of AI, obviously, compared to a human invention. So I think those aspects need to be debated more thoroughly going forward. The other issue that we think needs to be really addressed is the neglected cousin of the two, quality of patents and opposition systems, the opposition systems. One of the suggestions we have advanced in the past, and we do so now also, is that developing countries could, for example, propose in the SCP to undertake to sort of kickstart this again, revitalize this. This pillar is to propose a survey on opposition mechanisms to look at how these strengthen third-party challenges to patents. And essentially to look at opposition systems not as an impediment to patent office efficiency, but as a support, as something that supports and complements patent offices to do a thorough and robust search and examination of applications that come their way. So if you have any comments or questions on this, you could pause now. Thank you. Perhaps we can move on then to the next one. Now, key studies that will be discussed in this 36th session of the SCP will be on the issue of quality of patents. Again, there's nothing on opposition systems to be discussed except the headline in the agenda. So you have a study on unity of inventions and divisional applications. The unity of invention, essentially, as I said, multiple claims could be made in a single patent application, and we have given you some examples of this in our background note. And subsequently, if the patent office finds during the examination process that these claims are not do not comprise claims on a single invention, but would need to be separated, it could allow the patent applicant to file divisional applications. So, for example, you have a medicine for which the compound a patent is being sought. But then the claims also cover certain secondary uses of that medicine, or certain potential certain other forms of that medicine. Now, these could be subsequently filed, if the patent office allows it, as divisional applications. And this is often used by patent applicants as a strategic tool to file for patent applications, particularly in the pharmaceutical sector, towards the end of their original patent, as an evergreening strategy, creating patent tickets and market entry barriers for competitors. It also adversely impacts the examination workload of patent offices. And therefore, in the discussions under this study, what needs to come through more is to look at need for stricter guidelines on limiting the use of divisional applications. Some South Center papers have pointed this out. For example, one South Center study, which we can share with you, has pointed out examples how Australia, for example, through their Raising the Bar law, have put strict timelines on when beyond which divisional applications cannot be filed. And I think there is scope for looking at possible approaches to limit the use of divisional applications, so that while the flexibility that it offers to patent applicants is well and good and can be talked about, we also need to look at how to mitigate adverse impacts of divisional applications on quality of patents granted, on the quality of patent office work in terms of workload, etc., and in terms of the broader implications for public policy goals, particularly in the context of public health. There will be also discussion on artificial intelligence and patent processes. I mentioned this past, that focus will be on the role of AIs in patent examination and patentability of AI-generated inventions. Now, in this conversation, what needs to also be addressed is how to address transparency, bias, and patentability challenges in the context of AI-generated inventions and use of AI in patent examination processes. In that context, what we recommend is, again, to push for discussions on raising patentability standards, surveys to assess national patent examination capacities and how those could be impacted, and push for technical assistance to strengthen national patent examination capacities in a way in which patent offices are able to implement provisions of their national patent laws and standards under their national patent laws appropriately, and not essentially recognized as valid patents granted by one of the big offices. I may move on to the next topic, patents and health. Again, the context of the discussion on patents and health is that this was essentially triggered by a proposal by the African group and the Development Agenda group, which was a cross-regional group of developing countries that was in existence in WIPO for a few years, since around 2009 and thereabouts. And the proposal that was placed on patents and health was to essentially highlight that there are flexibilities under the TRIPS agreement, public health related flexibilities, which are relevant for the patent system. We all know about it, but there are challenges, and countries often find it difficult to make use of those flexibilities. And the idea was to propose a work program which would identify what are the challenges countries face in making use of those flexibilities, what are the constraints in making use of those flexibilities, and how do we overcome those constraints. Certain examples were proposed. An example was, for example, in the context of compulsory licensing. How do you, TRIPS allows you to grant compulsory licenses. It does not limit the grounds on which a compulsory license can be granted. There are some procedural requirements enshrined in Article 31 of TRIPS. But then when it comes to issuing compulsory licenses, countries do feel constrained. And the question was, what kind of guidelines, for example, are there? Could those be exchanged? Could those be shared? How to improve patent examination in relation to claims made on medicines, for example. It has a public health implication. What guidelines offices follow? Would there be the scope for declaration of the international non-proprietary name or the generic name of a medicine when a new patent claim on an existing drug is being filed? These were some of the questions that the SCP was called upon to address. But there was no substantive engagement on that proposal. Essentially, the discussions in the SCP sort of meandered into studies on patent flexibilities generally. What kind of flexibilities are there? What kind of flexibilities countries use? And not so much as addressing the constraints. Then there have been some discussions organized on, for example, the role of patent pools, etc., as side discussions in the SCP, but no concrete work product was developed or work program was developed to address the challenges that developing countries may face in making use of the flexibilities related to public health. So some of the recommendations that have been made, for example, include improving institutional capacity, simplifying legal frameworks for compulsory licensing. One of the recommendations that often come out from these discussions is promoting collaboration between WIPO, WHO, and WTO, the trilateral cooperation. But this trilateral cooperation is, again, a very, very informal sort of a collaboration. It does not necessarily, is not necessarily defined by what should be done in the context of that collaboration by the SCP. So there is no guidance that is there in terms of how do you make use of flexibilities, what kind of guidelines could be shared, etc. So there is need for advocating for enhanced technical assistance from WIPO, essentially, to implement the TRIPS flexibilities for public health, and to ensure that the SCP discussions are shaped in a way where they are conducted in a way where it provides necessary guidance to WIPO on how to help and assist developing countries implement the TRIPS flexibilities for public health. I go back to one of the points I made earlier today, that under the relationship agreement with WTO, implementation of TRIPS-related technical assistance is the responsibility that WIPO has assumed on itself. WIPO as WIPO Secretariat, and therefore it becomes all the more relevant and imperative that the SCP provides the necessary guidance to the Secretariat on how to deliver technical assistance when it comes to implementation of TRIPS flexibilities for public health. It is not sufficient just to, for example, provide a list of flexibilities which countries can use, but one needs to actually tell countries, how do you make use of those flexibilities? What constraints you may have, how do you overcome those constraints? Thank you. We move on to the next topic. Confidentiality of communications between clients and patent advisors. As I said, the context, the issue here essentially is that an advice. So suppose I'm a client who wants to obtain a patent in your country. I would go to a patent advisor who need not be a lawyer, registered in the bar, and therefore with a duty with a primary duty to the bar and to the court as an officer of the court. So I go to a patent advisor. The patent advisor has a discussion with me, looks at what I want to patent, and helps me draft the patent claim in a manner that I have exhaustive coverage as I could possibly get and I would like to get. In doing so, obviously, the advisor could tell me that don't, for example, disclose X or don't disclose X in this manner, but craft it differently, right? Just give you an example that we often talk about in our trainings with regard to secondary patents. Often, patent claims are filed on new use of known medicines, while patent laws don't allow patents to be granted on new use of a known medicine. How is this done? This is done by drafting the claim in a manner where we show that the claim is for the use of the known medicine for preparation of a new medicine to treat a different therapeutic condition. But you're a preparation of a different medicine, not a new medicine. A preparation of a substance to treat a different condition. This is just crafty drafting, really, and based on certain legal assumptions that some offices, such as the EPO, have. These are granted. These are known as Swiss claims. Now, if I am the patent advisor and I'm giving you the advice that let's put this claim, draft this claim as a Swiss claim, because otherwise it will not be granted under the law. That advice, is that advice going to be treated as privileged communication between the client and the patent advisor or not? Now, in some jurisdictions it is, but in many other jurisdictions it is not, because only when because a patent advisor does not have the same status vis-a-vis the client as the lawyer has. So the proposal is that this should be, has been for a while, that this should be recognized. But the issue, as developing countries have pointed out in the SCP, that the issue pertains more to the law of evidence and civil law in many countries than specifically patent law. What kind of communications between clients and particular professionals should be regarded as privileged is a matter of the law of evidence, and therefore goes beyond the limited scope of patent law itself. And there has been opposition to any norm setting on this issue. Soft law norms were also proposed. This should continue in our view, because essentially a discussion on this has been can distract attention away from more pressing matters such as patent quality and public health, which would be important issues to address in the SCP. Thank you. Now let me turn to the last item on the agenda, transfer of technology. Now, broadly speaking, discussions in the SCP have largely overlooked how patents impede technology transfer. The initial idea of having transfer of technology as an agenda was to discuss how patent system impedes and therefore how the patent system needs to be reformed to effectively allow better technology transfer. But in the recent past, in particular, discussions have focused on how the patent system contributes to effective technology transfer. So it's basically turning it the other way around, the entire perspective. The assumption is the patent system works for technology transfer, and we are now only going to discuss how the patent system has contributed to effective technology transfer from that assumption. The challenges to technology transfer in the context of the patent system include high licensing costs, restrictive patent requirements, and complex ownership structures, according to the studies that have been presented in WIPO by the Secretariat. In our view, and these are our recommendations, some of the key areas for action that needs to be pursued are to look at patent disclosure formats for key technologies. So we could say pharmaceuticals, renewable energy, for example. What would be the patent disclosure formats? To do some freedom to operate analysis, to assess what are the licensing practices on technology access. So focus on how licensing is done. Also do a study on royalty rates and anti-competitive provisions in patent licensing. I think those would be important elements to consider. Current discussions in the SCP do not move in that direction, but our recommendation is that certain proposals could be made for future work to reshape the orientation of the discussion and transfer of technology in the SCP. So finally, these are broad recommendations on the SCP. Generally, developing countries need to ensure flexibility in patent laws to address public health and other public policy priorities. And these should be pursued in the SCP under relevant agenda items. And these are not just the agenda item on public health, but also agenda item on exceptions and limitations, quality of patents and opposition systems, as well as transfer of technology, which become relevant in this context. Patent opposition systems, specifically in relation to the agenda item on quality of patents and opposition systems, needs to be specifically addressed and given a boost up. And there is also at the same time, as far as quality of patents is concerned, there should be a push for stringent criteria for examination of patent applications. There should be advocacy for more robust technical assistance from WIPO in the use of patent flexibilities and creating tools that would assist WIPO Secretariat to do so. And that directly links up to the issue of exceptions and limitations and the use of draft reference documents. Also, SCP needs to focus on real issues of technology transfer mechanisms. Proposing, for example, at this stage, we could say studies on patent disclosure, royalty rates, competition in licensing agreements, etc. So I would stop with that. And if you have any questions or comments, we'd be happy to take it. Thank you. So colleagues, if anybody would like to take the floor and make any comment, we could take a round now.
So Nirmaya, I think we've come to the end of the briefing.
Right. I don't see anyone asking for the floor, I think. So, yeah.
All right. So colleagues, thank you very much. Thank you, Nirmaya, for the comprehensive presentation. And as you know, you should all have received the background note. Feel free to contact us, and we hope that you will have a very good session of the Standing Committee on Patents. So thank you very much. Have a good day.
Thank you. Bye. Have a good day.